Good afternoon, sir. Good afternoon, Dr. Abuja. Welcome.
Good afternoon, sir.
Welcome to you. Yes.
Thank you.
Good afternoon, Father.
Thank you. Go ahead.
Thank you, Father. A very good afternoon to one and all present here. In today's world, artificial intelligence is rapidly transforming and improving the ways that industries like healthcare, banking, energy, and retail operates. However, there is one industry in particular that offers incredible potential for the application of artificial intelligence technologies. That is the education. The opportunities and challenges that the introduction of artificial intelligence could bring to higher education are significant. At present, colleges and universities face a wide range of challenges, including disengaged students, high dropout rates, and the ineffectiveness of traditional one-size-fits-all approach to education. But when big data analytics and artificial intelligence are used correctly, personalized learning experience can be created, which may in turn help to resolve some of these challenges. With a personalized learning experience, every student would enjoy a completely unique educational approach that is fully tailored to his or her individual abilities and needs. This could directly increase the student's motivation and reduce their likelihood of dropping out. It could also offer teachers a better understanding of each student's learning process, which could in turn enable them to teach more effectively. Keeping this in mind, Xavier Law School, in collaboration with the IQAC of St. Xavier's University, Kolkata, is organizing this webinar on artificial intelligence and copyright. This webinar is in consonance with the theme of World Intellectual Property Day 2022, which focuses on intellectual property and youth innovating for a better future. Professor Dr. Vk Abuja, Vice Chancellor of National Law University and Judicial Academy, Assam, is our honorable speaker for today's webinar. With this note, I would like to invite Reverend Father Dr. John Felix Raj, Honorable Vice Chancellor of St. Xavier's University, Kolkata, to kindly deliver the welcome note. Over to you, Father.
Thank you. Thank you so much for your introduction. Good afternoon to all of you. And I'm happy today is the World Intellectual Property Day. And on this auspicious occasion, I want to extend a very warm welcome to Professor Dr. Vk Abuja, Vice Chancellor, National Law University and Judicial Academy, Assam. Sir, thank you very much for accepting our invitation to be with us this afternoon. I also want to thank him and also thank his National Law University and Judicial Academy for extending cooperation in creating IP and youth, innovating for a better future, and upholding the theme of World Intellectual Property Organization. I want to thank Xavier Law School for organizing this webinar. I'm sure in the spirit of creating awareness, in the spirit of knowing more about this theme and topic, that you are organizing this, and I'm very grateful to the Dean and all those student volunteers and faculty members for taking this initiative. This webinar is to create awareness on intellectual property rights among the students, among teachers and researchers, and to make use of the same at length for the benefit of individuals and institutions, and as well as our nation. Creativity and innovation are vital, especially in the field of education. They spur economic growth, create new jobs, create new industries, and enhance the quality of life in general. The progress and well-being of humanity depends on our capacity to come up with new ideas and creations. Technological progress requires the development and application of new inventions, while a vibrant culture will constantly seek new ways to express itself. Intellectual property rights are vital. Inventors, artists, scientists, and business leaders put a lot of time and their financial resources, their energy and thought into developing their innovations and creations. To encourage them to do that, they need the chance to make a fair return on their investment. That means giving them rights to protect their intellectual property. However, artificial intelligence, which we call AI, continues to emerge as a general purpose technology with widespread applications throughout the economy and society. This poses fundamental questions that sit at the heart of the existing IP systems. Does AI innovation and creation need IP incentives? How should the value of human invention and creation be balanced against AI innovation and creation? Does the advent of AI require any changes to the existing IP framework? These are some of the questions rise in our minds. On this note, I welcome once again our honorable guest and all you taking part in this webinar. And I leave the platform to our honored guest, Dr. Vk Abuja, Vice Chancellor, to address the audience on the nuances of artificial intelligence and copyright. And I'm sure, sir, your input will enlighten us and create a lot of awareness among us. Thank you very much, and God bless us all. Thank you.
Thank you, Father. May I now request Dr. Priyanka Datta, faculty member of Xavier Law School, St. Xavier's University, Kolkata, to kindly introduce the speaker.
Thank you, sir, very much. So, a very good afternoon to all of you. Let me have the honor of introducing to you the honorable speaker for today's webinar, Professor Dr. Vk Abuja. An academician par excellence, Professor Dr. Abuja earned his master's degree in law from the University of Delhi and his MPhil from the Jawaharlal Nehru University, New Delhi. Having completed his PhD from the University of Delhi, Professor Abuja began his illustrious academic career, and in the past 26 years of his academic pursuit as a faculty member and a researcher, he has established himself as an acknowledged scholar of intellectual property laws and international law. Professor Dr. Abuja has also completed a course on law teaching and legal research skills at the Cardiff Law School, Cardiff University, United Kingdom. Professor Abuja has also authored 4 books on intellectual property rights and international law and 2 volumes of Halsbury Annotated Statutes of India. Sir has published over 50 articles in acclaimed national and international journals and scores of book chapters. He has also edited 1 book on human rights and co-edited 7 more books on the subjects of legal education, intellectual property rights, human rights, mediation, and international law. Professor Abuja has also delivered special lectures at forums like WIPO, World Intellectual Property Organization, then at Delhi Judicial Academy, Bihar Judicial Academy, and Jharkhand Judicial Academy, Ranchi, at UTC refresher programs and orientation programs. As an exemplary teacher, Professor Abuja was awarded the prestigious first prize in the 5th South Asian Teaching Session on International Humanitarian Law and Refugee Law, which was jointly organized by the International Committee of the Red Cross and UNHCR, United Nations High Commission for Refugees, and the National Law School of India, University, Bangalore in the year 2003. A person of diverse talents, Professor Abuja has not only gained academic distinction, but has also emerged as a proficient administrator. Having served as a joint director, Delhi School of Public Policy and Governance, established under the Institute of Eminence, University of Delhi, and professor in charge, Law Center 2, University of Delhi, Professor Dr. Abuja has taken over as the Vice Chancellor of the National Law University and Judicial Academy, Assam, in June 2021. It is a great privilege for us to have you over here, sir. Once again, I welcome you to this webinar on behalf of our Excellence family. Now it is over to you, sir. Thank you.
Sir, you are muted.
Can you unmute? Yeah, thank you.
Father Dr. John Felix Ras, Honorable Vice Chancellor, St. Xavier University, Professor Pratyusha Das, Professor Priyanka Datta, all respected teachers and dear students, a very warm afternoon from Guwahati. My internet connection is not very stable because we are facing problem for last 2-3 days, and in between, if you are not able to see me, or if the quality goes down, kindly let me know. I'll be talking for 40 minutes on artificial intelligence and copyright, and I'll take the help of PPT. Please give me a minute. Is the PPT visible?
No, sir. Till now, it is not visible. Now it's visible, sir.
Okay. Move नहीं कर रहे। So, Professor Stephen Hawking once said that the development of full artificial intelligence could spell the end of the human race. And that was a very strong statement which he made. He died 4 years back in 2018, and he could see, when he made this statement that this is what is going to happen in future. He further stated that AI would take off on its own and redesign itself at an even increasing rate, and humans who are limited by slow biological evolution could not compete and would be superseded. He's no more, but of course we remember his words. AI has assumed significant importance in the contemporary times, and its use has become indispensable in almost everything. Let it be health, transportation, aviation, space, education, entertainment, whether it is music, art, games, films, industry, or any other sector. Now, a tendency has been developed in all the countries to automate most of the activities of the human beings so that the human intervention could be reduced to the maximum and efficiency could be increased, and at the same time, there should be no probability of any error. And that is why if you just look at the aviation sector particularly, the most of the things are being automated to rule out the human errors altogether. I'll just give you an example and you will see how this AI is evolving. Google AI system has created a child of its own, and that has happened a few years back. The child AI is being trained by the parent AI to such a high level that it outperforms every other human-built AI system. The performance of child AI is evaluated by the parent AI, which acts as a controller. And this process is being repeated thousands of times to make the child AI more effective and advanced. It was just one year back only, before I took over as Vice Chancellor in NLU Assam, that I could come across news where a new AI system which was called as GPT-3. It has spent several months in learning the ins and outs of the natural language by analyzing thousands of digital books, the length and breadth of Wikipedia, and nearly 1 trillion words, which were posted to blogs, social media, and the rest of the internet. The GPT-3 AI, it writes poetry, tweets, responds to questions, summarizes emails, translates languages, writes computer programs. It can understand vagaries of human language, and it can tackle other human skills. Today, if you look at AI as a whole, you can find that AI can write news articles, it can generate artwork, it can write novels, it can generate music, it can produce games, and it can do many more things. Now, this AI, artificial intelligence, is not a new term, as it has become a buzzword today. It was coined way back in 1956 by John McCarthy. If you look at the legal definition of artificial intelligence, there is no such legal definition of the artificial intelligence which has been given by Indian legislature, or I did not come across the legal language of the artificial intelligence. It may be stated to be the ability of machines to do things that people would say require intelligence. So all those things which the human beings can do through their intelligence, the same thing can also be done by machine by using their intelligence, which is artificial in nature. AI normally refers to the ability of machines to perform cognitive tasks like thinking, perceiving, learning, problem solving, and decision making. All these things which were being done by human beings can now be done by the artificial intelligence. Artificial intelligence as such, it is a broad field actually, which has got many subfields. So you might have come across many expressions like machine learning, robotics, language processing, deep learning, etc. Now, in machine learning, there happens to be an inbuilt algorithm in the computer program that allows it to learn from data input and to evolve and make future decisions either at its own or on the direction. In other words, the machine learning algorithms learn from the programmer's provided inputs to generate something new by making its own independent decisions. Well, friends, there are two categories of artificial intelligence created work. One is the AI generated work and second one is AI assisted work. And you need to know the difference between the two because the authorship will change. Now, when we talk about AI created works, I mean the work which has been generated by AI, these are those works, which have been generated autonomously by artificial intelligence, and there is absolutely no human intervention. So the AI may change its behavior during operation to respond to unanticipated information or events, and it can produce work which might not have been intended or anticipated. Now, because it is not being controlled by the human beings, so obviously, you cannot even think of what kind of output would be there, and it can just respond to, if suppose there is some unanticipated kind of information or event, which come across, the artificial intelligence is able to handle with that, and it can bring out some result which you might not even have thought of. The second category is the AI assisted works, where it requires the significant human intervention. So you are taking the assistance of artificial intelligence, but the work is being created by the human beings with the human intervention. Now, if I take you back to 1970s, when these computer programs were being used for copyrighted work, you could see that computer programs were considered merely tools to support the activities, and the human intervention was required for production of the work, right? But today, with artificial intelligence in place, the computer programs have the potential of generating the works independently by taking their own decisions. So there is a paradigm shift, when you see the computer programs were started way back in 1970s, and if you see the things, which are taking place today. In copyrighted work, there is a requirement of originality. Fine. Now the question is there originality in the work which has been created by the artificial intelligence? Now the requirement of the use of skill and judgment. So when we say originality, that means, where you have used your skill and judgment in producing some kind of a work. So the requirement of skill and judgment in originality may be deemed to have been satisfied by virtue of the programming and the parameters on which such AI actually compiles and creates the work. So we can easily say that the work created by AI are original, in nature. Well, friends, the basic problem which is being faced throughout the world in all the jurisdiction, whether it is United States, whether these are European countries or India or any other country, and that problem is of the authorship. Who is the author of the work which has been created by artificial intelligence? And obviously, authorship will decide the ownership. Now, this is something which is extremely important. There are three categories, three broad possibilities when we talk about authorship. Number one, the copyright system which we have today should recognize authorship for artificial intelligence. The copyright law says that author is the first owner. Now, unless you assign copyright to somebody, so you being an author will also be the owner of copyright. But once you assign copyright to somebody, then you are the author and that other person becomes the owner. But here, the first possibility is that copyright system should recognize authorship for AI. Second possibility could be that there should be no authorship in AI generated work and the work should fall into public domain, right? That there should not be any copyright in the work which has been created by AI. Number three, there should be a sui generis law rather than copyright law to protect the work created by artificial intelligence automatically. Now, let's have a brief discussion about human creativity versus machine creativity. The problem which comes first of all is the personhood. Human beings have been recognized as a person, but what about artificial intelligence? That is a very debatable question, very contentious question at the moment, and we'll have a discussion on that. So personhood is one issue which had to be addressed. Then the AI may use biased and toxic language, which may result in defamation or obscenity. It may incite violence on the lines of caste, creed, or religion, or it may produce any other undesired result. So if it is something which has been created by AI without human intervention, it may result into all these things. And if it happens to be so, then who is going to be responsible for obscenity, for defamation, for inciting violence or other things? Because you cannot punish artificial intelligence. Further, the AI generated work may happen to be substantially similar to an existing work. Now, suppose I have written a book and the AI which has created a book, on the similar topic, it turns out to be substantially similar, maybe because the artificial intelligence was taking input from the material which was available on the internet. And if my book was there, say, for example, on internet, so there may be a possibility that, there is a substantially similar kind of an a work which is substantially similar to an existing work may be created by artificial intelligence. So there may be copyright issue, copyright infringement issue, that who is going to be responsible for that. So obviously, since AI doesn't have the personhood, then how to fix its civil liability or criminal liability? And if AI is treated as an author, it will not be entitled to transfer ownership in the work in absence of personhood. Now, even if you treat artificial intelligence as an author under copyright law, how the AI is going to transfer the ownership in the work because it is not a person? So these are some issues. But at the same time, personhood has been given to artificial intelligence in some of the jurisdiction. For example, European Parliament has advocated to grant the legal status of electronic persons to autonomous robots for copyright purposes. There is AI virtual artist technologies, music composing. Now, this AI system has become the first in the world to be officially given the status of composer, right? And it releases music and it also gets royalties under the name AIVA, that is artificial intelligence virtual artist. Now, this is one example where the Europe has gone little ahead and has given it the status of composer. Saudi Arabia has granted citizenship to AI humanoid robot Sophia in 2017, that all of you must be knowing. Now, there is another issue which comes up, that is about moral rights which have been provided under Section 57 under the title Special Rights of the Author. Now, these moral rights are available to author. And there are two types of moral rights which are available. One is the right of paternity or the right of authorship. For example, if I have written a book, my name will go on my book. So that is, right of paternity because my work is my intellectual offspring. I'm the author of that. Second is the right of integrity. My work should not be mutilated, modified, or distorted in such a manner which is prejudicial to my honor and respect. Fine. So if there is a distortion even after the assignment of copyright to somebody, then obviously I can bring a case for damages and injunction against that particular person. Now, how would you give moral right to artificial intelligence if you consider artificial intelligence as an author? Artificial intelligence, it hardly makes any difference for it, whether its name goes on that particular work or not. It does not make any difference, if that AI work has been distorted, because it is not going to be something which is against the honor or respect of the artificial intelligence, because it is not a human being. So that again raises a question, how would you decide the human right issues then? Another thing is the term of copyright. Now, since I have written a book, so the copyright will subsist in my book for throughout my life and for 60 years after my death. So it is author's life plus 60 years. That is the term of copyright. Now, artificial intelligence doesn't die because it is not a human being. So since it does not die, so how would you decide, the term of copyright? That again is an issue, if the authorship has been granted to artificial intelligence. Further, it will be difficult for AI to negotiate the royalty with others and enforce the rights. So in absence of the personhood. Now, there are people who say that there should be no authorship to artificial intelligence work. And they say that the work which has been generated by artificial intelligence without human intervention should fall into public domain, and there should be no right given to anyone over that work. And then they further argue that as no cost is incurred in AI generated work, it should be made accessible to public for free of cost. Now, AI is capable of creating any number of iterations of works created by it for no extra cost or resources, right? So there is no, cost involved as such. So once a work has been created, you can just make any number of copies of that particular work. So without incurring any further expenditure. Copyright law motivates author by providing economic rights and moral rights to motivate them to produce more works. Whereas artificial intelligence, being a non-human, does not require any such motivation to create the work. Now, if I have written a book, my book is being protected by law. So obviously that gives me, a motivation to write another book. So I know that if I keep on creating the original work, original literary work, or if I keep on, writing the books, my work will be protected by the copyright law. Right, my work will not be distorted, and if it will be distorted, then I'll be taking action, as per the provisions of law. So there is a motivation for doing more and more work. But if we talk about AI, if we make AI as an author, since it is non-human, it does not require any motivation whatsoever to create the work. So therefore, one of the argument is that let us not give any authorship to AI works, and let all this work which has been created by artificial intelligence without human intervention should fall into public domain and should be made free for all. But then there are other people who say that authorship to AI work should be given. And then they say that if you do not provide any protection to AI generated works, that would mean that no authorization is required, no fee is required to be paid, no royalty is required to be paid. And that will, turn into a death knell for those companies which are investing huge amount in the AI system to generate the works. The smart people will start commercializing such works in various ways without incurring any cost, and they will compete with companies which invested the money. Therefore, some protection may be needed for AI-generated works to encourage the AI programmers and the companies for further investment in the AI-related R&D. So the second view is that some sort of protection is required for AI also, so that the companies could keep on investing, money in AI-related R&D. Otherwise, it will become free for all, and if it falls into public domain, then obviously it will be commercialized. The people will start commercializing it at the cost of others. The third model, as I told you, could be the sui generis law. The AI generated work may also be protected under a sui generis system. Now, what is that sui generis system? The sui generis means a system of its own, it's of its own. I mean, when we talk of Plant Varieties Act, the Protection of Plant Varieties and Farmers' Rights Act, there also it is something, a law which is a sui generis law, a law of its own kind, where you can just make a law by taking, your local, social, political, economic, cultural conditions into account. You make a law, by taking all those circumstances into account. Such a system, the sui generis system, may have lesser protection in terms of copyright duration and other things. So duration of such work may be set as low as 5 to 10 years. In case of copyright, it is like author's life plus 60 years. But here, what is being stated is that let us not, dilute the copyright law. Let us not amend the copyright law. Let us make a different law, a sui generis law for the protection of work which is being created by the artificial intelligence. Let us provide a shorter duration, for protection. It could be like 5 to 10 years or maybe more. This will give rise to significantly less interference with the existing norms of copyright law. So this is what I said, that do not, touch the Copyright Act as such. Sui generis right may be similar to one conferred on databases in some of the jurisdiction in some of the countries. And the rights so granted may prevent outright and unfair exploitation of the work. Now, this will result into a win-win situation in the sense that the AI generated work will not be available for free of cost, right? So unfair exploitation will not take place. And on the other hand, a shorter duration will be given, shorter duration of protection will be given to the AI generated work. Now, if we just go to UK law, in UK, there is Copyright Designs and Patents Act 1988, what we call as CDPA. And there is a term which is computer generated work. And that term has been defined. It has been defined as the work which is generated by computer in such circumstances that there is no human author of the work. So human intervention is not there. So it is a work which has been generated by the computer. Now, according to section 9.3 of the CDPA, the author in the case of a computer generated work is to be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. Now, this again gives rise to two interpretations. When it says that the author will be considered to be the person by whom the arrangements necessary for the creation of the work are undertaken. Now, who is that person? The person who made the computer program or the person who is the user? Now, some argue that where a user takes part in the selection of data, which is to be fed to the AI system, then the user should be considered the person who initiated the process to create the work. The user, therefore, should be taken as the person who made the necessary arrangement to create the work and not the AI or the programmer or the company which owns the AI. So consequently, the user should be assumed to be the author of the AI generated work. Yeah, I missed that slide, So as I told you, the first argument was that the authorship in computer generated work goes to the programmer and not to the user. And the second is that it goes to the user, right? There is a case like Express newspaper versus Liverpool Daily, where the court stated that computer is basically a tool in the same manner as a pen is regarded as a tool, right? So when we use a computer program, when we use Microsoft, it works as if some paper sheet has been given to you on which you are going to write, right? So therefore, it is stated that some say that it is the person who had made the programming of that computer program. He should be taken to be the author of all that work, which has been generated by the computer. The others say that no, since the computer program has been purchased or it has been licensed and it is being used by the user, and user is selecting the data and feeding to the AI. So therefore, the user should be taken as the author of that particular work. If we go to United States, there also the author of AI assisted work may have the copyright if he establishes that the AI program was used as a tool or medium in the creation of the work. Now, if I can say that I have taken the assistance of AI, but then I have used the AI program as a tool or medium, and there was a human intervention from my side, I have been doing everything, but I am taking the help of AI, then I will be considered as the author of that work which has been created. But if it is generated by AI and there was no human intervention, then obviously there is an issue, because there I will not be taken as the author of that. Now the question is, who is going to be the author of that? Again, there is no answer to that as of now. In Naruto versus Slater, which is known as monkey selfie case, the court in the United States held that monkey could not be taken as the author of the selfies which it clicked, right? So that means that intention of the legislature in the United States is not to give copyright to non-humans, right? So the copyright was denied to animal, to the monkey in the United States. Copyright in a work can only be conferred on a human author and not on animals and machines in the United States. Now, moving on to the Indian position, what is the Indian position? So Indian position is also not that great, we are also facing the same problem. The Copyright Act defines author in relation to computer generated work as the person who causes the work to be created. Again, that causes a problem. Who is that person who causes the work to be created? Is it the programmer of the computer program, or is it the user? So normally the first interpretation is being considered as a better one. And so it is basically going towards the programmer of the computer program and not to the user. In Camlin versus National Pencil Industries, and that was an Indian case, sorry, that was an Indian case where the court stated, with respect to mechanically reproduced printed carton, that copyright is conferred only upon authors or those who are natural person from whom the work has originated. In the circumstances in case, the plaintiff cannot claim copyright in any carton that has been mechanically reproduced by a printing process, as the work cannot be said to have originated from the author. A machine cannot be the author of an artistic work, nor can it have copyright therein. So that was decided in the Camlin private versus National Pencil Industries case. The same remain the position even today. In Tech Plus Media versus Jyoti Janda, the court held that the plaintiff is a juristic person and is incapable of being the author of any work in which the copyright may exist. I'll just make one more submission here as far as Indian position is concerned. Few days back, hardly a week back, or may not be a week back, I got some news. There was some news item where it was stated that in Indian Copyright Office, co-authorship has been given to artificial intelligence. Now, that was something an eye-opener, and of course, it was a huge development. The very next day, I got another news item where it was said that the Copyright Office had withdrawn that order, right? Meaning thereby that we stand, where we were, and as of now, there is no copyright as such, in the AIS, in the AI. There is no authorship basically in the AI. If we go to international level, the first convention was Berne Convention for the Protection of Literary and Artistic Work, which was adopted in 1886. And, it was adopted in 1886. Nobody might have thought of any computer or artificial intelligence at that point of time. But it did not contemplate non-human authorship. Though this Berne Convention kept on revised, it was amended, it was revised. The last revision came, I think, sometimes in 1975 or so. It's sometimes in 1970s. Same may be true about TRIPS agreement, about WIPO copyright treaty, about WIPO performances and phonograms treaty, because none of them had contemplated, giving authorship to non-humans. But on the other hand, one can also argue that these treaty did not preclude the possibility of non-human authorship in the national legislations. So the national legislations could have gone beyond that, and they could have thought of, giving the authorship to the non-humans also. Now might be reading some news in the newspapers that I think it was latest in Canada, where a river has been given the personhood. And earlier it happened in Uttarakhand also, where a similar kind of adjustment came. So some sort of developments are taking place, but so far as IPR, the AI is concerned, we are still waiting for some development to happen. Now, this is a unique, issue, artificial intelligence and data protection. Now, artificial intelligence is, of course, based on algorithm. Now, AI application learns from data that has been used to train AI application. The data so used may be copyrighted and economically valuable. Now, the question arises whether use of data without authorization amounts to copyright infringement. Now, can there be a general exception in this regard? If an artificial intelligence application automatically produces a work similar to the original work contained in the data, would this amount to an infringement of copyright? If yes, who is going to be the infringer in such a case, and how the copyright will be enforced? Or should there be free flow of data in this regard? So these are some of the questions which are yet to be answered. As I told you when I was just talking to you about GSP, GST 3, when I gave you an example where I told you that the artificial intelligence has been fed a lot of a trillion of words, which were available on social media, blog, and Wikipedia, and on rest of the internet. Now the question here is that material which is available on internet may have copyright. Now the question here is, if you are training your artificial intelligence by feeding the data from the internet, which is copyrightable, or which is copyrighted, in which the copyright suggests. Now, does it mean that you are infringing copyright because you did not take the prior authorization? Or does it mean that it is free? Now, that again is, you do not find anywhere. Or can we say that there is a general exception? Now, that again, we cannot say because we do not find a general exception anywhere. So these are some of the issues, which have also come up. So to conclude, what can be stated is that there is no single foolproof rule to address the authorship issue in case of artificial intelligence when we look at from the point of view of copyright. Now, there will be significant ramification for offering non-human authorship to AI-generated works. So that is not that easy. Putting the AI-generated work in public domain is also not a good idea, as it will discourage the AI programmers and companies which own such AI to further invest in the AI domain. Sui generis system may be one of the options, which can be thought of, or alternatively, there should be some specific provision in the copyright legislations which are meant only for AI generated works. In any case, the AI generated works should be provided lesser protection, and human creativity should be preferred over machine creativity. With these words, I thank you all, and I'm really grateful to the St. Xavier University for giving me an opportunity to make this presentation. Over to you, ma'am.
Thank you, sir. We now move on to the question and answer session. Participants are requested to kindly fill the feedback form provided in the chat box. Sir, with your permission, we have got 2 questions. Can we proceed? Thank you, sir. So there's a question by Shuvangi Gupta. She asked, sir, can we bring strict laws against social media platforms who track user search result and display ads according to it, which in turn is a privacy breach?
This is something, where you need to have data protection law. It is not going to be addressed by this our discussion as such. You need to have a law in place before you can take these kind of actions. I agree with you that there are a lot of privacy issues which are taking place, and of course these companies are earning huge amount by adding a lot of advertisement. So obviously we need to have some sort of data protection law which can take care of this particular situation. So there was some development, some draft was made. So let us hope that soon we will be having a data protection law, and will be able to regulate their activities.
Thank you, sir. So the second and the last question is by Hibu Gupta. He's a second-year student of Xavier Law School. Hibu, can you please unmute yourself and ask?
Sevda, am I audible properly?
Yeah.
Okay. Thank you. Thank you, sir, for the wonderful presentation. I just want to ask one question, that in general, when we see, read, or even understand art, we see that it is an emotional creation or the emotional presentation of the creator, which has an equally powerful emotional hitting point on us, that we understand it not by always our brain, but by our emotions. Now, considering the fact that the thing we are talking about is a machine that in innate doesn't have emotions, but has something called algorithm, why are we even considering it to be a thing that should be come under an already gray area idea like copyright, patents, etc., when what it is just doing, it is acting on some algorithms which are pre-existing and given to it by a human, rather than having a lot of creativity and thinking and spending a lot of time thinking and visualizing it in general.
This is your name is Hibu Gupta. How do you spell it? I'm sorry.
Yes, sir, it's Ribhu.
Ribu. This was a wonderful question which you have asked. But then the problem is that, like suppose you and me, both of us are looking at some artwork. Fine. You can, sometimes you are lost in that artwork. You start perceiving the things, as has been shown in the artwork, and maybe that you realize as if you are there, within that artwork, and you are enjoying, you are completely lost in that artwork. That is one. Another is that, you go and look at it, and maybe that you admire, maybe that you do not admire, and you just go, so we are human beings actually. I totally agree with you. When a painter is making an art, he puts all his emotion into it, right? But then the question is how the people take it. He has made the art. Now it is for the people who are watching his artwork. So some may appreciate, the others may not appreciate. Now, if you look at artificial intelligence created artwork, there is no emotion. You are right, because algorithm had being a machine, it doesn't have the emotion like the human beings. but the work comes out to be so beautiful that the people start appreciating. Now, maybe the emotional people may not appreciate that. I mean, the emotional people may feel that, well, there is nothing like, which is an emotion which is involved in that. If you look at some of the artwork which has been created by AI, that is wonderful, very beautiful, right? So therefore, the requirement of copyright is the work should be original in order to be protected. And that requirement of originality is also satisfied here. That is one thing. I'll take this particular thing a little further. There is another area, patent, right? Now, the issue is there also because AI is inventing something which the person owning the AI might not have even thought of. You made the AI, you never thought of that the AI was going to make an invention. Sometimes it goes at its own and it produces some result which nobody might have even thought of. The question is, who is the inventor of that? And that may worth millions of dollars, maybe billions of dollars, because it is so important an invention which has been made by the artificial intelligence. Now the question is, who is an inventor? Again, the same problem, because it is a non-human, it's a machine, right? So giving inventorship to AI is posing the same issue as giving authorship to AI in case of copyright. Now, these are the two branches where, the AI is doing extremely well. There are enormous cases, many cases have come up in America and European countries where the AI had done inventions. But then the question is, how would you take them as invention? And if you do not take them an invention, then that means that it is free for all. So anybody can make it. So unless you get a patent for that, so it will be free for all. So once you apply for the patent, you file an application, and if you succeed, so you are going to get a protection for 20 years. But if suppose it is stated that, well, this invention is not to be recognized because it comes from a person, which is not a person, which is a machine, where the person who has not been given, where there is no inventor. Now, if there is no inventor, then obviously, protection will not be given, and the protection is not given, that means that it is open to all. These are the problem, because I again take you back to my original, the first slide, where I made this statement, what Stephen Hawking said, before he died, about artificial intelligence. Just on one day, one of my colleagues was telling me that he was talking to his wife regarding some lock and key or something, that they should have some lock of this type or that type, in the house or so. And I think they had Alexa. The next time they found, next day, they found a lot of fads, of the lock and key were there. Because maybe Alexa was listening, and on the basis of that, it had acted, whatever it is. So you can't even imagine to what extent the AI had gone and to what extent the AI will go. But yes, I do agree with you that it may not have that emotion. Once, we were having, it was long back, we were having a discussion. So there also I said, the machine cannot take over the human being. Like the emotions of human beings are, sometimes you are very happy, you are lost into something. Sometimes you are very depressed or so. Sometimes you are going to, when you are going to get married, you are into a different world altogether. You have different emotion. When a lady is going to become mother, when she's pregnant, she has a very unique experience, and she's very happy with how the life will go. A lot of emotion comes. You can't bring those emotion into a machine, into an artificial intelligence. When a baby is born and you become a father or a mother, you are into a different world altogether. Oh, my child is there, I have become father or I have become mother. So these kind of emotion may not come. Here I do agree with you, but then the question here is what the copyright says. It talks of originality, it doesn't talk of emotions. And so far as the work created by artificial intelligence is concerned, that can be considered as an original work, right? And so therefore, it becomes a subject matter of protection under the Copyright Act. But then the question is, how would you do that? For AI assisted work, there is human intervention. There is absolutely okay. There is no issue. But for artificial intelligence generated work, where there is no human intervention, there comes an issue. So let us hope that in coming time, some adjustment will come, or maybe the legislature will take some lead and will bring out some amendment in the Copyright Act, or will bring out a sui generis law, or will, provide some sort of protection to them.
Thank you very much, sir. May I now request Dr. Pratyusha Das, Dean of Xavier Law School, St. Xavier's University, Kolkata, to propose a vote of thanks.
Thank you, sir. I consider it to be my proud privilege to express my sincere gratitude to respected Professor Dr. Vk Abuja, Vice Chancellor, National Law University and Judicial Academy, Assam, for being our resource person and speaker in the webinar, Artificial Intelligence and Copyright. With his profound deliberation, Sir has highlighted the concept and applicability of artificial intelligence and copyright in the education sector in consonance with the theme of World Intellectual Property Day 2022, which focuses on IP and youth innovating for a better future. Sir, with your extensive knowledge and expertise, you have aided us in creating IP and youth innovating for a better future and upholding the theme of WIPO. St. Xavier's University, Kolkata would remain ever indebted to you for sparing your valuable time in enriching us. Inspired by the Ignatian charism, St. Xavier's University, Kolkata, under the stewardship of Honorable Vice Chancellor, Reverend Father Dr. John Felix Raj, is paving its way towards excellence. Reverend Father has always lighted our ways through his dedications and blessings. I express my regards and gratefulness to Reverend Father for always supporting our cause. Our learned Registrar Sir has always been a support for us. He never refrained himself to strengthen us in all possible ways by his thoughtful ideas and provocations for doing the best. Our earnest appreciation and regards to Sir. Respected deans, HODs, and faculty members of all the departments, you always strengthen us with your presence. Thank you for being with us and supporting our initiatives. Glad to get you beside us. The Faculty of Law, Xavier Law School, you are the pillars who witnessed the success stories, and my heartfelt appreciation for your efforts in shaping the school. Thank you, Dr. Priyanka Datta and Dr. Krishna Roy. My deep sense of appreciation to all the students of Xavier Law School who are our source of inspiration and commitment. My heartiest congratulations to all the student coordinators. My special thanks to the coordinator IT department, Mr. Malay Mitra and German, for helping us in successful organization and conduction of the program. Have a nice day ahead. Thank you, sir.
Thank you, ma'am. With this, we officially close the discussion. Thank you very much.